If there was a theme for tonight's show, it's a celebration of an organization that we have done our best in our own little way here at the Coalition over the last few years to lionize. And of course, that is the American Civil Liberties Union, most particularly the Providence, Rhode Island chapter, headed by one of my favorite people in the world. That would be, of course, Steve Brown. The ACLU, because of its unique role in American politics and American jurisprudence and American civil liberties, often becomes the, let's say, the political pinata of the moment, if you will. Folks love to hate it until one day they wake up and suddenly they need them. Regardless of your political affiliation, your religious, your ethnic background, at some point or another, I would argue that most American lives have been impacted, affected in a positive manner by a case that was advocated for by the American Civil Liberties Union. We believe in this organization here. On a personal level, as I've told regular listeners over the past few years, my political life was impacted by the writings of a gentleman named Nat Hentoff. Back in a newspaper called The Village Voice, some would say the grandfather of all independent media here in this country. Nat Hentoff both reveled in the notion that at some point in time, he managed to upset everybody. A gentleman like that, through his literature, who could both annoy, bedevil a range of political players from the Catholic Church to the Democratic Party to our friends over the Republican Party, who at this moment, my words, not my guess, I would admonish, as I hear you reaching for your mouse to click onto a different channel, tonight's a wonderful opportunity to embrace the Constitution. As we like to say in the Coalition, the Constitution is a wide world of testaments to the civil liberties of the American public. The Constitution goes beyond the Second Amendment. There's a number of fascinating areas that one can study beyond the Second Amendment. By the way, an amendment that we endorse and support wholeheartedly here in the Coalition. But the ACLU has impacted in its history literally every facet of American life. And particularly here in Rhode Island, where over the last few months, seemingly every municipality, our state government, some of its quasi-agencies, seem to continually run afoul of them. I thought it important tonight to bring on a number of what I'll call my heroes of civil liberties. No one embodies that more than my guest joining us tonight, and that is, of course, attorney Tom Lyons. He is a partner in Strauss Factor at Lyons, a firm practicing corporate litigation here. Product liability defense, I'm told. Who in his mild-mannered days routinely inhabits a courtroom on behalf of a number of business issues. But, if you will, much like Superman, seems to have found perhaps the one telephone booth left in Rhode Island, maybe it's behind the Garrity Center, and changes into what I'll call one of Rhode Island's heroes of civil liberties, a super lawyer, if you will, willing to advocate on a wide range of issues over seemingly an entire career. When it got out to one of my Republican conservative friends that Attorney Lyons was going to be appearing this evening, he texted me this morning and said that he was the attorney of the ACLU of the decade. Such is the stuff of what we need here in Rhode Island. It's not enough for us to posture politically, to get enraged, to obsess on social media. We need people to take the battle to where it counts most, it would seem, in American politics today, and of course that is the courtroom. So, without further ado, I would like to introduce Attorney Tom Lyons. Welcome to the Coalition for the first time.
Thank you.
Thank you for joining us. You are a graduate of Colgate University, Case Western Law. The first questions I ever ask whenever an attorney, a cooperating attorney on behalf of the ACLU appears on the show or by phone, and thank you for coming down today. Number one, what type of lawyer, if you will, does Case Western turn out? And at what moment in your young legal life did you decide that you wanted to advocate on behalf of civil liberties?
I think Case Western turns out all different kinds of lawyers. I had the fortune to have a terrific instructor in litigation named McElhaney, who was one of the foremost instructors on the topic, and so I had a great course with him on it, which is how I got into wanting to do litigation. In terms of doing civil liberties type work, it actually started out when I was very early in my career at a different firm. Another lawyer who was with the firm, who's now also someplace else, named Howard Merton, had gotten involved in a case, and he wrote me into helping him out on the case. Right. And it's just been one case after another since then.
Let's talk about the relationship, if you will, because it's important let's dispel a few urban myths, first of all. You are a volunteer cooperating attorney, as it's been described in litigation, on behalf of the ACLU. Now, and again, I'm not an expert. I literally try to play one on the radio, so please feel free to correct me where I'm wrong, because there seems to be, despite its huge presence in the landscape of Rhode Island life, there still seems to be a lot of confusion about the role the ACLU plays. So, first of all, the ACLU technically doesn't sue anyone, correct? There is a plaintiff that you folks represent.
Correct. What happens is people will come to the ACLU or they're directed to the ACLU. We've done it both ways. The ACLU decides that they have a worthy case and it contacts one of their cooperating attorneys, and then there's an agreement reached among the three, the ACLU, the client, and the cooperating attorney, as to how to proceed. But the client is the client. We represent the person who is in need. There are occasions when the ACLU itself is a party to the lawsuit, depending on what the circumstances are, and our office has handled some of those cases. But in most of them, it is an individual or individuals who are, in fact, the plaintiffs in the case.
Because ultimately the challenge is when bad law is passed and signed into effect, it's not enough, or there is really no opportunity usually for a lawsuit to be engendered right away. Someone actually has to prove that they've been harmed. And so then, in a sense, and there's a term that I don't like to hear, but we'll just say for once, there's the accusation out there that the ACLU is posturing and going victim shopping. Now, that couldn't be further from the truth, correct? I mean,
all of the cases in which I have been involved, there was someone who had contacted the ACLU looking for help. In a couple of them, someone had contacted us directly, and we had said, you may want to talk to the ACLU, and then Steve Brown gets back in touch with us and says, we're going to represent Mr. So-and-so or Ms. So-and-so, and we'd like to retain you as the attorney to do so. Right.
And this is important because in a situation that we've discussed on an ongoing basis over the last few weeks, and actually featured Stephen Brown and Steve DeSoy of the Rhode Island Medical Association, there was a situation where Gina Raimondo signed into law legislation that allowed for warrantless searches of the Rhode Island State Prescription Medical Database. Now, the challenge there is that in order for us, and I say us, but in order for the ACLU to challenge that law, we have to find, as a group of activists, someone who's been, at some reasonable level, it can be proven that they've been harmed by that.
Correct.
And that's often the biggest challenge, because there's a lot of, my words, not yours, a lot of junk law out there that can be nefarious, but at the same time, you simply can't, despite all public opinion and late night commercials to the contrary, you simply can't traipse into court and just announce you're suing someone just because you feel like it, can you?
Correct. You have to have what they call standing, which generally means that you have a specific articulable interest in the legal controversy.
Right. So, without trying to put you on the spot with regard to any specific case or specific, and there's a case at hand that we're going to be discussing in a few minutes, but in general, is Rhode Island particularly adroit at generating bad law that seems to keep Mr. Brown and his staff occupied on nearly a full-time basis, around the clock, 7/24? Because when I looked at some of the towns that have been party to challenges that we're going to discuss later on tonight, when I look at just the cases that we've covered here in the coalition, whether it be Smithfield trying to pass its own medical marijuana program, despite the fact that one clearly exists in law. You look at the situation with UHIP. You look at the situation that we're going to discuss tonight. You look at the panhandling law. You know, on and on and on, going back years, for which, again, it would appear that there is substantial precedent, for lack of a better term, as a non-lawyer, that exists that would speak to these city councils and mayors, and in some case governors, that this is madness.
I will be honest with you, I don't know that Rhode Island is any more likely to generate bad law than a lot of other states. I think the difference in Rhode Island actually is that Steve Brown has available a large number of attorneys who are willing to act on behalf of the ACLU and its clients. And that's why there seem to be so many of these kinds of cases here. I think in lots of other states, there's probably a similar amount of dubious law, but fewer lawyers who are willing to get involved.
So it's even from my perspective, in my limited exposure to the legal community here, there seems to be a real ethos, a real can-do attitude for lawyers who are willing to dedicate a significant amount of time, despite all the pressures of running a private practice, all the challenges of running a private practice, the expenses of it, a real willingness to just jump right in and fight these. Is that from a long-standing tradition? Is that something recent?
I think it has been true for quite a while. I don't know. You'd have to ask Steve. You know, how much it predates my involvement, which at this point probably goes back a good 25 years. But there's a lot of lawyers in Rhode Island who are certainly willing to help out. And I don't know what makes Rhode Island any different from any other jurisdiction. I just am happy that that's the case.
Okay. So then, when you win a case, as you've done, and let's, one of the most notorious examples that I don't believe you were involved in, we'll just use this as something that's memorable, you have the Cranston prayer banner. The municipality at that point in time, again, please correct me, ended up reimbursing in terms of the legal fees, it's been said anywhere from $100,000 to $150,000 because of the far-ranging nature of that litigation. What happens to those expenses once they've been awarded?
Well, what happens is that the agreements that are in place between the ACLU, the client, and the lawyer provide that the lawyer and the ACLU split the fees. So that part of it goes to the lawyer and part of it goes to the ACLU to help with its expenses of running its operations. Right.
But in no sense does this represent a boon to anyone's business, does it?
I wouldn't say so, no.
It's folks who haven't worked in a professional firm environment, I don't know if they're cognizant of the overhead that it takes, anything from legal subscriptions to folks who act in a purely research capacity for lawyers to work with, to litigate towards. Also, there are the cases that you might expend a great deal of time on that you might not win, and might not provide little or any rewards to the attorney.
We had a case that our office was involved in a few years ago, in which we sued the Rhode Island Family Court over the operation of its truancy court program. We achieved a favorable result in the Superior Court. There was an appeal to the Supreme Court, and the Supreme Court decided that a intervening administrative order entered by the Family Court had mooted our claims, even though they were meritorious. In other words, the Family Court had decided that perhaps it would resolve our complaints about the truancy court system. That was a case in which we technically at least did not prevail, we did not get attorney's fees, but it involved a very, very substantial commitment of time.
Right. So you win some, you lose some, but ultimately the motivating factor for a law firm to do this is what?
Well, you're still doing good, and actually, we count that case as a win
Mhm.
because the circumstances that we were complaining about when we filed suit were changed.
Right.
It was changed voluntarily in that case by the family court, which is why it technically wasn't a win by us. But in any case, even if you don't prevail, you have often done some good either by clarifying the law, or in some cases you have to some extent helped somebody with their circumstances, even though what you got was not technically a win.
Right, and that harkens to this UHIP-related situation where the ACLU has stepped in and begun a legal challenge to state agencies who then, at least the first go-around, gave lip service to be willing to comply. Now the ACLU is back at it again because, my word's not my guess, but shockingly enough, the state of Rhode Island doesn't seem willing to comply with at least the spirit of its original arrangement.
Mm-hmm.
So it's just not legal, it's just not a pure Perry Mason moment that you're going for. You essentially act as you put up the iceberg for the ship of state to run afoul of should they continue, again, my words, not yours, maintain this madness. You've got situations, and I know this is not a case of yours, I believe, so I'm not looking to. And in a situation, by the way, like this, where an attorney is willing to join us on the air, where he or she are involved in ongoing litigation, I'm looking more towards the underlying legal logic and some of the impacts of the case, as opposed to attempting to try the case on the air. But you've got situations now where what we're about to discuss, and for example, the panhandling ban, where it's been litigated at some level, relitigated, relitigated, despite significant case law out there across the nation. Do you think it's just political expedience that these folks are going after? It baffles me.
I don't know the background of the panhandling litigation, so I would be reluctant to comment on it. I would say that in general, it is sometimes my impression, not necessarily in those cases, but perhaps in other cases, that the defendants sometimes prefer that a court order them to do something than that they agree voluntarily, perhaps for political reasons.
Okay, fair enough. What brought you into the news cycle for this week was litigation that you've entered into against the town of Bristol. And this is a situation, and again, as I always say, feel free to jump in. There was a tragedy. A young man took his life via the use of a firearm. I don't believe any of that's in contention, doubt whatsoever. The family has asked to be and essentially remain anonymous as far as the media goes, and so we obviously respect that right because of the tragedy involved. The town of Bristol, as part of the legal investigation, took the firearm, and I guess was the entire firearm collection that he had?
Yes, he had a number of different firearms, and they seized all of them, not just the one which was involved in the suicide.
Right. Now, at this point, my understanding is that the firearms, minus the one involved in the suicide, have been returned.
Yes, the young man's parents were appointed the executor of his estate, and subsequently, over a period of time, all of the other firearms, except the one involved, were returned. When the father requested the return of the one, a handgun, he was told that he would have to go to court and get a court order to get that one back.
Now, just on a human level, here you have a parent in the worst situation imaginable. Their child takes their own life, and you're being told by the legal authorities that essentially you're going to have to relive this nightmare over and over and over again, simply for the return of property that has got to be just a minefield for them. You know, I mean, for the love of God, my comments, on a simple level of human decency. Now, my understanding, again, in this, by the way, if you go to coalitionradio.us in our blogs, you'll see that we've posted both the ACLU statement as well as a link to the court filing. What's their rationale behind this?
You mean the town's rationale?
Yeah.
Well, what they have said, and we've had other somewhat similar cases involving other cities and towns, and to the extent that a rationale has been articulated, it is that they think somehow that getting a court order will protect them in case something bad happens involving the firearm later on. That no one will blame them for having voluntarily relinquished it. There was a court order in effect that required them to do so.
And on what legal basis then? And because, there's clearly in any litigation that's this sensitive and this difficult, there's an emotional issue, which typically is what the media and folks obsess over. And then there's the pure legal issue, So under what basis do you claim, as you have in the past, the ACLU and different attorneys have claimed in the past, the right to this property? How are you challenging them?
There are several different claims that are being presented in these cases. One is the state has a so-called Firearms Act, which provides very explicit circumstances under which law enforcement can seize and retain weapons. Mm-hmm. And our position is that none of these circumstances fall within those situations set forth in the statute. In addition, we argue that the Second Amendment prohibits the seizure and retention of the firearms without a good cause, which doesn't exist. We argue that the Fourth Amendment, which prohibits unreasonable searches and seizures of property, mm-hmm. It is also violated by these procedures. And finally, we say that the 14th Amendment involving due process is violated, where the towns do not provide some sort of procedure to get the firearms back short of going to court and getting an order.
So if you're an amateur civil libertarian like myself, you've hit 3 out of the big 4.
Okay.
Pretty much in one filing. All that's missing is the First Amendment.
Yeah.
This being Rhode Island, I'm sure that'll come up at some point. Let's split off for a second. A question I often ask attorneys who are involved in civil liberties cases: is the Fourth Amendment, is it my imagination again, or is the Fourth Amendment under siege in this nation?
Well, that is an interesting issue, and one of those important issues comes up in this case. Not necessarily in this case yet, because we've only just filed the complaint, but in some of the other cases we've had, the argument has been raised that there's an exception to the Fourth Amendment known as the community caretaker function, okay, which the police claim, which allows them to seize property even when there's not a crime, if it is for the sake of protecting the public or the person, mm-hmm, or the person involved. This is a very, very hot issue in Fourth Amendment jurisprudence right now. It has never been expressly addressed by the state of Rhode Island's courts. Mm-hmm. So in fact, we may see whether or not that happens here. My hope is that the state of Rhode Island would take a very jaundiced view of this, mm-hmm, or at the very least only permit it to be applied in very narrow circumstances, because otherwise it's the exception, as the academic critics have said, swallows the whole. In other words, if any time the police feel that it's in the good of the public that they seize, mm-hmm, property, then they can seize property, and then the whole need to go get a warrant goes right out the window.
Where does I'll call this a legal attitude, where does this spawn from? as an amateur, I would define myself as somewhat of a strict constructionist in terms of constitutional law. Now, I know people who actually practice constitutional law look at that as kind of sort of a vague, kind of hobbyist term. But how does a concept like that rise up?
Well, it rises up because the police, in a few perhaps genuine circumstances, need to do something with someone's property, but perhaps may not have a good time to go to court to get an order.
Right.
The most generally accepted sort of circumstance, or the one that doesn't seem to engender any litigation, is when, for example, there's a abandoned vehicle on the highway,
Mm-hmm.
and you want to move the vehicle so that it doesn't cause
Right.
a car accident or something like
Mhm.
that. In that case, the police may take it into their custody to remove it from the highway and put it someplace. And then the owner can come back and get it at some time in the future. They haven't gotten a warrant, but maybe they felt like
Right.
they couldn't in the circumstances. That's the most commonly accepted example that I'm aware of for this function.
So that's the moral equivalent, if you will, of not shouting fire in a crowded theater for the First Amendment. That, you know, these real world sort of anachronistic occasions happen, but from that spawns an entire school of thought.
And in fact, as I said, there have been quite a few occasions on which the police have seized other property not involved in a criminal investigation, no crime ever charged, and have said that they had to do it due to their quote-unquote community caretaker function. So there's a lot of litigation around the country about this.
Now, is the entire concept of a warrant under attack in this country?
Well, I would say that there are more circumstances in which that is an issue, and in fact, just recently, the Rhode Island Supreme Court issued a decision, State versus Terzian, in which and when I say recently, I mean this past June, in which they threw out evidence in a criminal conviction because the police had seized, coincidentally, a firearm from a residence without a warrant, and the Rhode Island Supreme Court held that there was no exception which justified them seizing the firearm without a warrant, and then overturned a criminal conviction as a result.
And that, of course, is the logical extreme. That's how far this can be. If law enforcement takes it to that extreme, what's at risk? Because ultimately, the legitimacy of the conviction is not based on someone's actual guilt. In a sense, it becomes a process issue. And is that an example of the police simply looking beyond their responsibilities, or is that just happenstance?
Well, there was an actual criminal investigation going on in that case. But what had happened is the defendant had been arrested and removed from the residence. And the police conducted a search, found the handgun, which became the subject of a criminal complaint, but they never got a warrant for it. And the Supreme Court said, once the defendant has been removed and there's no emergency situation that requires you to proceed without a warrant, there's no reason why you can't make a phone call, for example, get a warrant,
Right.
and then conduct a search.
Right, and getting back to the state's prescription medical database, when Mr. Brown was on the show, he pointed out that there doesn't seem to be any hue and cry in Rhode Island that the bench is withholding warrants, is there?
I'm certainly not aware of it, and in almost every city and town that I know of, they have municipal judges who are available by phone
Right.
that you can reach. The state court judges are available. I mean, their cell phone numbers, I understand, are known to law enforcement. They can be reached. So I am not aware of any circumstance in which it has been impossible for law enforcement to reach a judge to request a warrant. Now, Has it happened? I suppose it could have under some extreme circumstances, but I'm not generally aware that it's a problem.
Right. So then, again, my words, one has to question then the motivation of law enforcement seemingly, and this is, by the way, this is, obviously with terrorism on a federal level, and then on a state level when it comes to these type of crimes, some of which, of course, one could construe that are victimless, what the state's obsession is with needing an ever-increasing reach for warrants without the safety net, if you will, of a judge involved. Again, it baffles me.
Well, I don't know that I could speak to the issue of the requirement or why it's not being adhered to. I would imagine the reasons could be very numerous and different.
Folks, if you're just joining us, Attorney Tom Lyons, who is one of our heroes of civil liberties, he's a cooperating attorney on many levels with the American Civil Liberties Union here in Rhode Island, is joining us live in studio here at Coalition Radio Broadcast Headquarters, 90 Weybosset Street, Providence, Rhode Island, at the Go Local Live Media Center. We're discussing both a specific case, a case in which the ACLU has engaged with a plaintiff in a lawsuit against the town of Bristol for, in the ACLU's position, a violation of the Second, the Fourth, and the 14th Amendment regarding Second Amendment rights, illegal search and seizure, and due process. We are, in this segment, of course, sponsored by our friends at iServices LLC. Computer networking, computer software, virus detection, server maintenance, internet marketing, SEO needs. Please support those folks who would sponsor independent media like the Coalition Radio. Again, iServices LLC. Links to them can be found at facebook.com/the Coalition Radio, on the Mighty Mighty Twitter at Coalition_radio, and of course, this broadcast and so many others will be live forever at facebook.com/Coalition Radio, our YouTube homepage, and at coalitionradio.us. The ACLU has a long and storied and complicated relationship with the Second Amendment, doesn't it?
Well, it does. My understanding is that different affiliates around the country have different views as to how willing they are to undertake Second Amendment cases. Fortunately, here in Rhode Island, they've been willing to do so in a number of cases.
The case in D.C., where some would argue for the first time a court with high standing argued on behalf of the individual rights to own weapons, more specifically, and I'm referring to the ACLU website, which discusses their relationship with the Second Amendment, as opposed to support of a militia or organization to maintain a stock of weaponry. Has that had a material impact here yet in Rhode Island? Heller, I'm talking about?
Well, we had actually had a prior case in which I was involved because the ACLU filed an amicus brief, which had established, at least in part, the right under the Rhode Island Constitution to keep and bear arms. So the Rhode Island Supreme Court had in part anticipated the U.S. Supreme Court's decision in, I think you're referring to the Heller case.
Right.
However, Heller, to some extent, went beyond even the Rhode Island Supreme Court's decision. So, in part, the Rhode Island Supreme Court was ahead. In part, the U.S. Supreme Court then pushed even farther ahead. Okay. So,
getting back to the situation in Bristol, what are the next steps? Because, again, I appreciate you coming in studio because we get an opportunity really to educate the public as to the whole process. That this isn't just a media headline, that there's a significant amount of work by you, folks in your firm, and the ACLU in a sense, for lack of a better term, prosecuting this case. What happens now? You felt the need to file, by the way, is this at the federal court level?
it is.
Okay. And why would it be at the federal court level for our listeners as opposed to the state court level?
Well, because there are federal constitutional rights involved.
Okay.
And what has happened is we have just filed a complaint. The solicitor for the town of Bristol has accepted service of the complaint to be served on the town and the chief of police and so forth. The case, I have some hope that the case may resolve quickly. And I say that in part because two other cases, which did not involve suicide but did involve seizures of weapons that are still pending in the federal court, resulted in a decision in one of them in which Judge McConnell held that the town of North Smithfield had violated a person's constitutional rights by refusing to return his firearms unless he went to court and got an order. I think that decision would probably be controlling here. This case has also been assigned to Judge McConnell. We have forwarded that decision to the attorney for the town of Bristol. And shortly before we went online here, I received an email from him, which leads me to believe there's a possibility the case may be resolved very quickly.
You spoke about the earlier case that had ruled in favor of the plaintiff. Our case, and forgive my obsession with this issue, because we talk politics in this show, and we focus a lot on the micro level, at the town council level, the mayoral level. Because as intriguing, particularly after this week, as federal politics can be, I would argue that the type of your work you're doing, the ACLU is doing, and sometimes town council are doing, have profoundly more impact on the lives of everyday Rhode Islanders than any of the madness that can happen in any given day in Washington, D.C. When judgments or cases like this come down, in most municipalities, I would imagine, you've got a lawyer who is a part-time position with the town, a municipality, or the city, or the smaller cities, who is an active attorney practicing law. So the town solicitor, I'm sure, is aware of these type of situations. A few weeks ago, we had a gentleman from the Goldwater Institute come on, and he's developed quite a study, and it'd be fascinating reading for someone like yourself about the closeness, if you will, of municipal court judges, when they're appointed, and their role in fines, and the wall that doesn't seem to exist between the municipal court level and town councils. But in a situation like this, you would have hoped that there would have been communication. Wouldn't that have prevented all of this?
Well, I am inferring that there was not an awareness of the prior decision that we had obtained. In terms of what town solicitors do, honestly, they have a huge scope of responsibilities. And for example, I think well of the particular town solicitor who's involved in this case. I think well of a lot of the town solicitors. But there's a whole lot of things that they do. And frankly, the issue of when does the town have to return a firearm it has been seized is probably a microscopic fraction of their potential responsibilities even. And in a case like the town of Bristol, I have no idea if it's ever come up before. I mean, on a day-to-day level, they're probably more involved with zoning issues, other land use issues, school issues, that sort of thing. So this is for most town solicitors, I would think a very unusual issue.
Right, and I don't want to impugn them, because many of them work, despite all the cronyism that's sometimes alleged in these situations, because town politics are often very much too close. Many of these folks, again, work very long hours for really a stipend. Again, there aren't great riches to be made being the town solicitor for a town like Cumberland or Smithfield or things like that. It's very often, if the people are politically involved, they're doing this, I think, extending their participatory role in government. So I take the high road on that. But would you recommend at this point some type of, get all the town councilors in the state into the dunk and having some type of constitutional intervention?
Well, we have attempted settlement of the two other cases that preceded this one in federal court. And quite frankly, part of our hope was, and the hope of the judge who was involved in the settlement discussions, was that it would lead to a agreement that would constitute the basis for other cities and towns to handle a similar situation.
Mm-hmm.
Unfortunately, those discussions were not successful. But yes, this is a situation which does need to be addressed, because it is becoming increasingly apparent to us that it's not that they're not isolated, in the sense of there are a number of cities and towns which engage in these sorts of seizures.
Right. But is that also a function of the high level of control local police chiefs have over the firearms permitting process in general?
Actually, permits have nothing to do with this. All of these...
But I mean, that feeling of control that they have over that area.
Well, you know, it may well be that the police chiefs like to have no pun intended, a handle on the firearms in town.
Mm-hmm.
But none of the firearms in the cases we've handled have been, for example, assault rifles or anything like that. They've all been handguns or shotguns. In one case, it was a black powder muzzle loading, rifle.
Right.
That
a musket?
Yeah, just about.
Right.
Which had been seized. So I do not understand the reluctance of the police to return legally held, appropriate firearms to people.
Mm-hmm. Are you involved in any other issues right now in terms of litigation or negotiation, publicly at least, that you can talk about in terms of the ACLU?
Just those. I've done a number of other ones. I have, for example, I have represented food stamp recipients
Mm-hmm.
who were challenging the procedures by which their food stamp benefits were taken away.
Mm-hmm.
I have challenged people who were denied driver's licenses, for example, and the due process procedures by which they were denied driver's licenses.
Right.
So there have been a number of other cases. Right now, the only ones that I have with the ACLU are these three cases involving the seizure of firearms.
By the way, as an aside, some legal trivia, there's an interesting situation happening in Chicago with regard to Chicago's imposition of a soda tax and how that conflicts directly with federal food stamp regulations. And again, this is, in this case, I've got to believe that was completely unforeseen. But the entire essence of the legislation is now up for challenge in Chicago, this quote-unquote soda tax. I say that because a representative here in the state had proposed a soda tax. And the first question in my mind came up in reading this. I'm wondering if, by the way, because it seems like, and I empathize with folks who run municipalities, because the level of, I'll call it, my words, legal interference in the day-to-day runnings of a town and a city have got to be astonishing. Tentacles everywhere. And so your ability to trip over these type of issues has got to be profound. And the exposure in terms of legal fees. But at the same time, and we've got a mayor in this state with regard to, and I'm not going to ask you to comment on this, but the mayor in the state who has sworn that he will take the panhandling law to the Supreme Court if necessary. And what I will ask you is, in general, as a rule of thumb, what type of costs can a municipality incur running up this style of legislation?
Well, obviously the cost in any kind of civil rights litigation can be extensive depending on how far
Mm-hmm.
the case goes. Hundreds of thousands of dollars, perhaps
Mm-hmm.
more. If I recall correctly, The District of Columbia ended up paying attorney's fees in excess of $1 million because they lost the Heller case. Whether or not you do that obviously depends on whether or not the elected official believes he has the popular support of his town or city to pursue the litigation.
Right.
And if the voters feel strongly enough about it, I guess that's a mandate to do that, even if it turns out badly.
Right. And it's interesting because of social media and because of independent media now, folks are ordinary taxpayers, if you will, are coming to terms with the cost, and again, my words, not yours, what I'll call this vanity-style legislation that seems to be everywhere. Folks all of a sudden are getting a grip on that. They're no longer taking the curveball that their elected officials are throwing at them and just going along with it blindly. I think folks are starting to understand, particularly in an era where municipal budgets are so strained, where schools are going largely underfunded, some would allege, in a variety of communities. The notion of going out and spending hundreds of thousands of dollars to support this, what I'll call vanity legislation, is finally being recognized. And I think folks are starting to challenge not only the underlying notions or the constitutional issues, but I think folks are coming to terms with the practical issues here involved. And that was one of my goals tonight, was to really just kind of break down the process. If the folks in Bristol essentially, and I don't know if the term consent decree is that appropriate in this use? I mean, if they agree to walk away, is that at this point you've already got Rhode Island?
I would say that would depend, and that would also involve a discussion with our clients about how they want to proceed. The original weapons case that we had way back when involved the city of Cranston, and in that case, the client was perfectly happy just to get his weapons back, and there was a reasonable but small financial aspect of the settlement too, in which he received some money and some attorney's fees were paid, and that was the end of it. However, the other two cases that we have, which are pending in federal court, the plaintiffs are insistent that not only because they've already gotten their guns back, they got them back, but they want the municipalities to recognize that they have to have some sort of process in place to handle these situations going forward, because they don't want somebody else, the next person, to have to fight this fight all over again. Whether or not the town of Bristol, what approach they will take, what approach our clients would take in that circumstance where the gun is returned now, I'm not sure. So I'm not going to predict which way that will go.
When you look at all the cases we've discussed tonight, if there were no ACLU, what is the likelihood in your mind that many of these would ever have been heard or ever seen the light of day?
I would have to say that most cases that the ACLU handles would probably not see the light of day, because a lot of them are not going to result in big financial awards, so there's not a financial incentive for lots of attorneys to handle them. The ACLU acts as for lack of a better word, a clearinghouse to have these kind of cases come in. They sort through which ones they think are meritorious. If they find ones that they think are meritorious, then they begin contacting their roster, if you will, of cooperating attorneys and ask them to handle them. So a lot of these cases probably would not go to court without the ACLU's involvement, because the only thing that you might get out of it is an attorney's fee award if you're successful.
Right.
And that's often not much of an incentive for many attorneys, because as you have noted, you can lose and then you get nothing.
Right.
So.
And invested in some cases hundreds, if not thousands of hours in some of the more complex issues. Fair enough. The ACLU, I would argue, and I'm not an attorney, but I would argue in the court of public opinion, in the absence of the ACLU, And I'll use one of my favorite Jimmy Stewart movies as an example. It's a Wonderful Life. I would argue that life in these United States, in a place like Rhode Island, where you have, and I think very often it's good people just unaware of the legal ramifications of the decisions they make at the city and government level. I'm not here to demonize them in any way, but I think life would be measurably different, and we'd be far poorer if we didn't have this type of truly independent watchdog agency advocating on behalf of just plain folks. It would be, you would have government run amok. You would have people suffering under some of these bad laws. And going forward, as we continue to challenge things like the war on drugs or civil asset forfeiture, if the ACLU is in there, and individuals like yourself willing to give so much of yourself, the cavalry isn't sitting around the corner, are they? There's no one waiting to do things because it's the right thing and face these sort of overwhelming odds, both logistically, financially, and quite honestly, intellectually. What would we do?
I don't know. The analogy that occurs to me, to use a different movie, is that of Atticus Finch in To Kill a Mockingbird, and in which the attorney is in that case appointed, but willing to undertake a unpopular cause,
right,
in the hopes that it results in a greater good. And while I think there are, as we have discussed, quite a few attorneys in Rhode Island at least who are willing to do that, it's the ACLU which coordinates that activity and really helps make it possible by putting the client in touch with the lawyer.
There you have it, folks. Folks, Attorney Tom Lyons, one of our heroes of civil liberties, a cooperating attorney currently involved in litigation with the Town of Bristol, but just another chapter in his ongoing efforts, as so many lawyers have done, and we've had a number of them on the show, advocating for your civil liberties. I'll put up a post I haven't run in a while, which is called Why You Should Join the ACLU. It's an interview we did a couple of years ago when we were back on WPRO with Steve Brown, when we talked about the history of the organization, some of the cases from all sorts of political sides that they've taken over the years, both here and nationally. And I would challenge you to put down what your preconceived notions, your biases, your frustrations, and really address the issue really as a function of individual citizenship and liberty. Because that's what they need to be successful. They need all of our support, just so that they have the framework, the structure to be a clearinghouse, to be a support system for cases just like this. Thanks again, and congratulations for all the work you've done.
Well, thank you very much.
All right.
Thank you for having me here.
Folks, we're going to take a quick break right now. Of course, you are listening to the Coalition on the Worldwide Coalition Radio Network. Outrage, porn-free, civilly disobedient media, broadcasting here at 90 Way Boston Street in the city we love, Providence, Rhode Island, the naked city, the city of 1,000 stories. We're going to tell a couple more tonight. We've got another attorney on the line who, and again, folks, forgive me, I'm running a little late tonight, running a little bit long, but indisputably, I think you'll agree that the type of conversation offered by Attorney Lyons is certainly well worth it. CoalitionRadio.us, Facebook.com/The Coalition Radio, on the mighty Twitter at Coalition_radio. And of course, there's our apolitical, anti-crony capitalist, anti-Pawsock Stadium at Pawtucket is Home. We hope you'll follow all of them. www.fightthestadium.com. Go to that site. Please sign a petition. Please consider becoming an activist in the fight against corruption.